योगः कर्मसु कौशलम्.
Hi, this is Professor Raman. I teach at the Campus Law Center, University of Delhi. In this session, I shall be talking about licensing of intellectual property, and I'll try to explore the synergy of law and economics within the parameters of this concept. To begin with, I'd like to read out a poem to you all. The title of the poem is The Delicate Balance. Man was a hunter, and when he started to, law and property were then born together. When was it? It's not in my memory's leather. We know it riding only on imagination's feather. When things were available in nature for free, then they belonged to the marauder spree. To avoid the disputes being decided by blood, the norm of ownership sprouted like a little bud. From movable to immovable, the bud continued to grow. Things then belonged to the sweat of the brow. Man's labor was a subject then to protect. To own more became a respect. Limited were the things created with labor, but man wanted to own more than his neighbor. Intellectual creations were then added to the list. Man then wanted to capture whole world in his fist. When exclusive was the genre of all his right, drunk he became with the wine of his might. Bothered he was not about the people's plight, who would then give the mighty a fight. To transmute to order from such a chaos, public interest soon came across. The one is still permitted to own, but of sharing you cannot now be sure. As the people's lawyer laid bare this plea, it were the masses who shouted out with glee. But wait, are we not approaching the same old spree, where things were set just for free? Public interest came as a gift to wonder, but even this can verily become a blunder. Is it in man's destiny to go round and round and continue eternally with the same old wound? Owning and sharing must go hand in hand for expression, for invention, and also for that famous brand. Striking this balance is like playing with glass. Delicate it remains for the men of class. So, friends, I wrote it a few years back, and this just captures the sense of intellectual property. Those concepts which this poem exhibits, we shall be discussing during the course of this lecture. As this session is about licensing of intellectual property, so we begin with a question. Where do we find licenses? Where do we see licenses in our society? First is, do you see a license here? Do you see some licensing activity here? When you consume the soft drink bottle, is there a license of intellectual property involved in it? Well, definitely yes. Because the person who owns the trademark, the person who has patent rights over or trade secret rights over various aspects of this drink, is not necessarily the person who is manufacturing it. So that person has licensed out his technology, his trademark, his copyright, his trade secrets, and then the licensee of these things is ultimately the person who manufactures it and sells it to us. Do you see licensing here? When I go to the market to buy t-shirt for my kids, well, the t-shirt they have in plenty, but they are interested in a particular t-shirt. Why? Because their favorite cartoon character is printed on it. So is there a licensing activity here? Definitely yes. Because trademark license and copyright license allows the vendor of this t-shirt, the manufacturer of this t-shirt, to put that particular cartoon character on the t-shirt, right? Okay, so the software that we use, for example, Windows, is there a license here? Well, yes, because when you sort of buy a software, a CD containing, a DVD containing software, or when you buy a laptop and software is already preloaded in the laptop. So have you bought that software along with the laptop? Well, not necessarily. And usually it is not the case. You might have bought the machine might belong to you, but then the software that is contained in the machine and through which the machine is run is not sold to you. It comes to you through a license, right? And that license gives you the right to use that particular software. So we see licensing activity here. Do you see licensing here? The making of the films, the exhibition of the films, everything involves lots and lots of intellectual property license. So license is in book publication, because today in this technological age, it may be possible for all of us to print, produce, and market books that we write. But then, is it really feasible? I don't think so, because marketing a book would involve lots and lots of labor. It's a specialized business. The author, it is better for him to concentrate on his or her own skills, and that is writing skills. So, the whole publishing business, if we peep into, it is based on a model of licensing or assignments of copyright. Now, we see tasks of intellectual property lawyers. Now, we can divide or we can classify the tasks of an intellectual property lawyer into three parts. First is obtaining rights, second is exploiting rights, and third is protecting rights. And when we talk about exploiting rights, exploitation could be self exploitation or exploitation through others. When the owner of intellectual property invites others in exploitation of the rights that belong to him, it is mostly done through the legal instrument of licensing. Realize the importance of licensing. Now, transfer of intellectual property is a concept. Like most of the lawyers or all the law schools, they teach transfer of property as one paper. So, and in that paper contains mostly transfer of immovable property. Now, there is another concept of transfer of movable property, and there's still another concept of transfer of intellectual property. Now, in this lecture, we are concerned with the transfer of intellectual property primarily. So, this transfer could be contractual or non contractual. All transfer of intellectual property could either be contractual or non contractual. Non contractual, say for example, it passes through the operation of law, through will, etc., which is non contractual. And mainly it is contractual. A contractual could also be divided into various aspects, various forms it may take. It could take the form of assignment, could be lease or license, mortgage, or sale. Now, out of these five, the most important are license as well as assignment, on which we shall be focusing today. Now, let's come to licensing. Now, licensing, the whole licensing activity has been given impetus by three doctrines of law. What are those three doctrines? Let's go into them one by one. First is exclusivity of rights. Now, intellectual property rights are exclusive in nature. What does that mean? That they are exclusive in nature. Exclusive, the word means to exclude. When we say that I have exclusive rights, it means I can exclude all of you. I can exclude everybody else from the enjoyment of those rights. Now, let's take an example. Let's take the example of the right to visit a public park. Now, do I have a right to visit a public park? Is it a right? Is it my right? Yes, it is my right. Is it my exclusive right? Is going to public park? Of course, it is my right, but is it my exclusive right? Well, it is not exclusive right. Now, I own a car. I have a right to drive that car. Do I have an exclusive right to use that car? Well, yes. So, rights could be exclusive or non-exclusive. Intellectual property rights are exclusive rights. Now, this exclusivity, when we understand it, we understand normally in only one facet of this grand concept of exclusivity, right? Now, on the one hand, exclusivity means that right to exclude others. On the other hand, we want to make this whole world an inclusive place. We want everything, every concept, every facility to become inclusive. We don't want to exclude anybody. So why intellectual property says that these rights are exclusive? Now, it doesn't mean that the desire of law is to exclude everybody from the enjoyment of intellectual property. That is only half the understanding of the concept of exclusivity. The other half is the concept of inclusivity. How exclusive become inclusive? Because when law gives me a right, say for example, law gives me an exclusive right over my intellectual property. Law says that, okay, this right is exclusive, but then you have a duty, a corresponding duty to include all others. So this duty, this responsibility of including all others rests on the owner who has been given exclusive rights. So it becomes my duty, it becomes my freedom also. You can look at it from various angles. The same thing is the right and the duty and the freedom as well. So it becomes my right to include all others. It becomes my duty also to include others. Why I'm saying duty, why I am emphasizing on the concept of duty here, because if I do not include others in the enjoyment of my intellectual property that I own, then there are measures which the law can take against me, right? So though apparently it is exclusive right, but then this is only the outer shell, which makes it exclusive. If the people deeper into this concept of the whole concept of intellectual property, well, it tries to make it inclusive through various ways and means. Now this concept of exclusivity makes licensing possible. If the owner does not have exclusive right, then how can he license? How can he invite others? When he licenses others, he invites others, he makes it inclusive. Of course, he gets remuneration, he gets license fee, he gets royalty in return of that, but then others are also invited in participation of the or utilization of the intellectual property. So it is exclusivity of rights which make licensing possible. Now let's turn towards the second one. The second is intangibility of property. Now we know properties of various kinds, movable, immovable, all right. And then we have property like intellectual property. We have property like land. We have property like car. Okay. So let's say I have a car. How many persons can I invite in my car? How many persons can I allow the benefit, the usage of my car? Of course, there is a limitation. It depends upon the size of my car. It depends upon the size of the persons I invite in. For example, I'm driving to office, to my university, and then I see a few of my students. I can ask them to come in, but then how much? How many? Four, three, at most five. That's the limitation. So there is, because it's a physical object, I cannot invite more than a certain number. Similarly, how many people can I invite in my house? Of course, that depends on the size of the house, and then there is always a limitation. But now let us see the corresponding part. If I have a copyright and I have a book, how many people can I allow my copyright to be used by others? It is limitless. I can invite the whole world provided somebody is interested in reading my book. Suppose I have invented a technology. How many people can I invite in the usage of that technology? Well, limitless, because this property is non-rivalrous. Therefore, it is soft. Intellectual property is not material, of physical property. Therefore, it is intangible. This property, this intangible nature of the property gives impetus to licensing activity, because potentially I can invite n number of persons in utilization of my property. Now let's move to the third concept which gives impetus to licensing activity, and that is freedom of contract. We know we have there is a body of law, there's a very important body of law which is known as contract law. All right. Now, where is this contract law contained? Let's take the settings of Indian legal system. Where is this law of contract contained? Now, this law of contract is contained not at one place. Of course, there is one legislation called the Indian Contract Act 1872, where laws relating to contract have been consolidated. If we read the preamble to the Indian Contract Act, and it says it is an exercise in consolidating. All right. So it is a consolidation where a lot of contract law is contained, and especially the basic principles of law of contract. But that does not mean that it contains all the law of contract. Now, if we see the arena of the context of intellectual property, a lot of contract law is contained within intellectual property statutes as well. So this basic law of contract, that is Indian Contract Act, together with the contract law which is contained within intellectual property statutes, they give a broad freedom of entering into a contract to the owner of intellectual property. Now, exercising this freedom, the owner of intellectual property can freely license or assign his property. So, taken together, these three basic doctrines of law, exclusivity of rights, intangibility of property, and freedom of contract, they together make licensing possible and feasible. All right. Okay. Now, a question for you. I know this lecture is recorded and you cannot answer in real time. But as you look at the presentation, listen to my lecture and answer this question. The whole practice of intellectual property can be divided into three parts: creation of intellectual property, protection of intellectual property, and exploitation of intellectual property. Now, my question to you is, which comes first? Whether creation of intellectual property happens first, or protection of intellectual property happens first, or exploitation or utilization, that means, of intellectual property happens first. Which out of these three comes first? Pehle kaun si aata? Now, I know the usual answer would be, first somebody has to create intellectual property, then protection, and then its utilization. That is the normal cycle that we are attuned to. But let us stop and peep into the practices of the world. Now, first is, let me take an example of a person who is a producer of a movie. He wants to make a movie, and the first thing that he requires to make a movie is a script. Now, the script is not there, so he asks somebody, a writer, an author, and he. Okay, so if we peep into the practices of intellectual property, the whole practice of intellectual property can be covered within these three aspects: creation of intellectual property, the protection of intellectual property, and the exploitation of intellectual property. Now, I wanted to ask you a question. Which out of these three limbs of intellectual property comes first? Which one comes first? Now, I know that it's not real time, it's a recorded lecture, and there's no possibility of your answering, but think for a while. If we say that these three limbs cover the entire gamut of the practice of intellectual property: creation, protection, and exploitation, then which comes first? Now, most of us would be tempted to answer that creation of intellectual property comes first, and then protection, and then followed by exploitation. But let us wait for a while. Let us peep into the practices of intellectual property in various industries. First, let us take the example. There is a very simple example. There is a producer of films. He wants to make a film. Now, what he wants is a script to make a film. He doesn't have the script. So, what does he do? He contracts a script writer, an author. He tells him, okay, are you prepared to write a script for a film for me? The writer says, okay, I will do that. The producer explains what kind of film he wants to make, the plot, etc. And then the author says that yes, he will do. He will write the whole script within a period of 2 months. And then they talk about the money part of it. The producer says, what will you charge? The author says, okay, I will charge 20 lakh rupees. 10 lakh rupees you give me now upfront as upfront payment, and 10 lakh you give me when I hand you over the script. The producer says, okay. Now, in this situation, has the intellectual property been created? No, the script is nowhere in the picture. It has not taken birth as yet. Has it been exploited or sold away? Yes, it has been. Because there is a contract of license between the author and the producer of the film, and the author has already got a part of the remuneration. So exploitation has already taken place before the intellectual property had been created. So we can say that yes, intellectual property can be exploited before its creation, and the laws of intellectual property, they support this kind of exploitation before the creation. So let's look into another kind of industry. There is a company, there is a person who starts a company, and what he wants is he wants to produce a medicine for treating coronavirus, the prevailing epidemic of coronavirus. So he employs 10 scientists. They're world class scientists, and he employs them. And he says that, okay, all of you 10 individually and collectively will work for me for a certain period of time for creation of a drug of this kind. Now, the drug is not there, but the producer, the owner of the company, he enters into a contract with all those 10 scientists, whereby all those 10 scientists agree to work towards invention individually and collectively, and they also state in the contract that whatever they will create during the course of their employment will belong to the company, and this will be the remuneration. So they start getting remuneration from the first day, but then we do not know whether there is a cure for coronavirus as yet or not. Something which is we are groping in the dark. So whatever they would create, it has already been exploited by way of licensing by those scientists. So as I mentioned earlier, the laws that we have regarding intellectual property, they support such kind of practices. So in real world, when we look into business practices, what we find is that exploitation of intellectual property many times, it's not always, but many times it precedes the creation. So the practice of intellectual property many times starts with exploitation of IP and then creative process begins. So there lies the importance of licensing as a tool to exploit intellectual property. It's a tool. Licensing is a tool to creation of intellectual property as well in this manner. Let me go to the next slide. Just a second. Let me see if I can make a present. Okay. Yeah. So is intellectual property wealth in itself? What is the role of licensing in business and economy? The first question is intellectual property wealth in itself? Well, we say that intellectual property is very powerful today. If I ask you a question, what is the biggest company in this world today? Go very big. What is most powerful company or business enterprise? So let's take examples according to fields. So for example, in computing, let's say Apple. Apple is one big giant multinational company. Now let us look into the assets of that company. What is the biggest asset of Apple? You won't say plant or machinery, you would say it is their patents. Because Apple makes phones and computers, etc. And the biggest source of their wealth is the patents that they have, the technology that they have. So it is controlled by intellectual property. Let's look into another domain. What is another big company? So let's say a big pharmaceutical company, Pfizer. What is the biggest asset of Pfizer? It's again not the traditional form of plant or machinery or anything. It is the patents and the trade secrets that they have on their drugs, on their medicines that they produce and they are going to produce. So again, in that domain, it is their patents. Look into another domain. What is the biggest asset of, say, for example, Nike shoes, Nike company? Now it's in their technology, it's in their patents, and more so, it's in their trademark. So their trademark becomes the most important asset that they have. So we have taken at random examples of various giant multinational companies. And these days, what we see is that there is a concentration of all the business in those multinational companies. That's the reality of the world. And their biggest asset is invariably intellectual property. So intellectual property is extremely important in today's world. Now, the question is IP wealth in itself? Well, no, it is not. It can be converted into wealth if it is made to flow. Right? How you flow it? The flow is ensured by the usage as well as usage through license. Now, the second question is it really possible for the creator to utilize his property himself? Well, technically, it may be possible, but then if we look into the practices, it's seldom possible. In the process of creation, various multinational companies, especially big companies, they create lots and lots of property. and they have large intellectual property portfolios. And then many times it happens that by the time the intellectual property is created, they no longer require it. And many times what happens is they create something, some intellectual property, use it for a certain period, and after that it is no longer required. So what do you do with that intellectual property that is still alive? For example, a patent that is still alive, or a trademark or copyright that is still in subsistence, but then you find that you do not require it. So one way is to hoard it, but then that's not really a very prudent business practice. So big companies, they have intellectual property portfolios, and specialized persons were known as managers of that intellectual property portfolio. So they pass all the intellectual property through audit and find out which property is reaping them what kind of rewards, and what were the expenses in creation and maintenance of that intellectual property. And then if they find that it is possible to, or it is profitable to license that technology which they do not need, or that intellectual property which they do not need, then it's worthwhile, because if it if they just hoard it, it will just vanish after some time, it will expire after some time, right? So next question is it possible or feasible for businesses to create everything in-house? Well, it is definitely not possible. If we see a small device like a mobile phone or a computer, it has hundreds of patents in it. Now, if, for example, I pick up a Samsung mobile phone, has the Samsung company made all those hundreds of inventions that have been used in the phone? Well, definitely not. There is no such company that has made all, especially in the technological arena. It's a crisscross of sharing of intellectual property through licensing. There would be dozens of patents which Samsung is licensing in. There will be dozens that it is licensing out for making a device. So it's not possible, it's not feasible, it's not profitable for businesses to create everything in-house. They have to depend upon licensing, and a sound licensing strategy is inevitable, is definitely required for any profit-making company. And then the next question is, the greatest economic value of intellectual property comes from, and there's no doubt, it comes from licensing. Is licensing dispensable? Well, it's not. We have seen that it is licensing that is absolutely important for any business enterprise. Okay, then licensing is a strategic tool for innovation. It allows one to concentrate on one's core competence. For example, there is a person who is a scientist, and or for example, he's an author. So, what do you expect of an author? To write books, or to go to the market and make arrangements for selling the book? So, he can concentrate on and put all his energies in writing, and leave the rest to somebody who is specialized for that. Right? So, he can license out his copyright to a supplier, a publisher, or by whatever name he is known as, and then just focus on his core competence, that is creating. So this is made possible only through the instrument of license. The second is access to new markets and new properties. For example, a person is stationed in Mumbai and he wants to do business in Chennai, in New Delhi. So, or let's take an example, a person is stationed in India, do business in Africa and Latin America. It's a pharmaceutical company and he wants to expand. Now, what he finds is that he has no presence, no business presence in those countries, in African countries or Latin American countries. What he finds is there is a business potential. But then it may be risky to go to those countries, and it may be beyond his wherewithal to go there and do business. So what he can do is he can appoint a licensee or various licenses in those different jurisdictions. So without going there, he can access new markets. Same is the case with testing new markets and technologies. So it's not necessary for a businessman to risk everything for testing. He can employ others through the instrument of licensing to test. And those are the persons who are specialized and who have a particular market presence or who have a specialized knowledge or experience of testing newer technologies and markets. So licensing makes it possible, turning infringer into ally. Now, what happens is, what is one of the traditional ways in which we perceive an infringer is that he is our enemy and sue him, pin him down to the instrument of law and courts. Well, that is of course true, and that's a real benefit. Without that, all laws will come to a naught. But then, from the business point of view, it may not always be the only prudent business option. Now, if you see, for example, you go to a new market and you want to see that an infringer is already there, your product is already there being sold, and without your permission, somebody is making it, somebody is infringing your intellectual property. So, one thing is sure that that person who is infringing knows how to utilize your intellectual property. So, one way is sue him, other way is ask him and invite him to shake hands with you. All he needs to do it, he continues to do what he was doing. All he would require is just to give you a license fee, and that's all, a royalty. If the infringer is ready to do that, then there is no harm. He becomes your business partner, he becomes your licensee, and it is a benefit for him because now he will, the threat of the sword hanging above his head, the sword of a criminal complaint or a civil litigation will be removed with that kind of a license. So that may be an issue worth exploring, that you can, through licensing, you can, or it may be possible to turn an infringer into a friend. Utilization of intellectual property that the owner doesn't use. As I mentioned prior to that there are various technologies that were of use to you before but are not useful to you now, may be licensed out. Then risk management also I talked about, because all the previous points are concerned with risk management as well. Going to new markets, testing new markets or new technologies, they may all be very, very risky. And there are persons, there are organizations who are specialists in risk management, risk taking. All right. So you can employ those organizations or persons through the instrument of license. Now, licensing that way is a strategic tool of business, wherein it becomes like a joint venture, wherein one person provides his intellectual property or pools in his intellectual property, and the other one his ability to exploit the same. So it's a kind of a joint venture, business joint venture. Now, Professor Raymond D. Nimmer has written a great book on licensing law. Now, what he mentioned was that licensing is a convergence of intellectual property and contract doctrines. And now there's a quote from his book. He says, thinking of contract and intellectual property as isolated and discrete boxes of principles is an impoverished idea. Law as a practical discipline relates to human activity which defies being boxed. So, if we look at licensing law, what are the various branches of licensing law, or what are the various theories which go to contribute, what are the various laws which go to contribute, which go to make licensing law? First and foremost is law of contract. So every license comes in the form of a contract. The form is contract. So it is the law of contract which regulates the form of any license. So first and foremost, licensing law contains law of contract. And where is law of contract contained? In India, if you take the example of India, there is a specialized legislation that is known as Indian Contract Act 1872, which contains the general principles of contract law. However, the principles of contract law contained in Indian Contract Act are not exhaustive. There is a lot of contract law which is contained in other statutes. Now, for example, for our purpose, there is a lot of contract law which is contained in intellectual property statutes also. For example, copyright law, patent law, and trademark law all have certain provisions regulating the contract specifically for intellectual property. So contract law, the general contract law, the special contract law, both in they both form part of licensing. Third is intellectual property law. Now, intellectual property law provides as the contract law had provided the form, intellectual property law provides the substance of any license, any intellectual property license. So, IP law informs licensing law, it becomes a part of licensing law. Then, other fields of law are also important. For example, competition law. Now, these days we talk a lot about certain licensing agreements becoming anti-competitive, or they go against competition law. So competition law also in that sense becomes a very important part of licensing law. It informs licensing. Then consumer protection law is also important, which we shall also talk about a bit later. Then taxation law, the treatment of royalties, treatment of lump sum money, consideration, as we say, is very important. Whatever you earn through a license, how to tax, how the government wishes to tax. So all these are very important for licensing law. But in broad strokes, if we have to choose two, law of contract and intellectual property, and then some others. Okay, influence of intellectual property law on license contracts. It defines the scope of rights. Intellectual property laws may provide for requirements over and above the requirements of general contracts. It determines the scope of the license. It may provide for default or background principles. Parties to license may assert certain rights against third parties who are strangers to contracts. IP law may provide for compulsory licenses, especially in the case of patents and copyright also. IP laws may provide that certain intellectual property rights are not licensable. IP law may provide further that additional non-contractual remedies are there, which we shall talk about later also. Now, contract is the vehicle of any intellectual property license. Contract is the only means to affect an intellectual property license. So we were talking about the influence of IP law on license contracts. It defines the scope of the rights. IP laws may provide for requirements over and above the requirements of general contracts. It determines the scope of the license, may provide default or background rules. Parties to license may assert certain rights against third parties who are strangers to contract. It may provide for compulsory licenses. It may provide that certain IP rights are non-licensable, may provide additional non-contractual remedies. Now, contract is the vehicle of a license. Contract is the only means to affect an intellectual property license. There is, of course, no other means. It is essential that all the requirements be complied with, because essentially every license is a contract, has to be so. So it's essential that all the requirements of a valid contract are complied with. Now, what is the form of a license? Is writing of licensing required? Well, if we go into the general law of contract, writing is not a precondition. It is not a requirement. An oral contract is as binding as a written one. But intellectual property statutes, for example, Patents Act or Copyright Act and Trademarks Act, they ask for written. They prescribe writing, necessary writing. Signatures, well, yes, it has to be signed. Then certain intellectual property statutes require registration of license, and certain others do not require registration. Now, types of licenses. Licenses comes in various hues and forms. A license could be exclusive or non-exclusive. It could be sole, pure, statutory, compulsory, clause license. So I've listed here the major ones, but then there are, of course, there are other variations of licenses. The most important one is the distinction between exclusive and non-exclusive license. Now, what is an exclusive license? Exclusive license means a license that excludes all others. So when I grant a license to you to use my intellectual, which is exclusive in nature, I grant an exclusive license to you. What does it mean? It means that one, I shall not grant such a license to anybody else except you. Second is, I shall myself not utilize that property. That is the meaning of exclusive license. Now, non-exclusive license is the reverse of it, the opposite of it. Though it is only permissive in nature. When I grant a non-exclusive license to you, it means that I am permitting you to utilize my property, but then I can permit all others, many others, to utilize the same property. I can, of course, myself, I remain competent to utilize my own property in case of a non-exclusive license. Now, what is a sole license? In case of a sole license, it is similar to a non-exclusive license and exclusive. It lies somewhere in the middle. Sole means that when I'm granting a license to you, I am saying that you shall be the only licensee. That means I shall not grant such a license to anybody else. But then what is the difference between exclusive and sole? The difference is that when I grant a sole license, I myself remain competent to utilize the property. So, technically speaking, sole license is a genre of non-exclusive license. And pure license, it's a contract where it only talks about licensing of intellectual property and nothing else. But there could be contracts which talk about licensing of intellectual property, and there are so many things which are talked into that contract as well. Statutory means when the statute has already granted a license. Now, this terminology you find in especially Copyright Act, Section 31. Now, it talks about statutory. Statute means the statutory license means the statute has already granted the license. It need not be granted by the owner of intellectual property. The statute has already done that work. Now, normally when a statutory license is granted, it is granted when the statute mentions or prescribes certain conditions. So anybody who fulfills those conditions has a license, right? Then compulsory license, we all know, it also is a genre of statutory license. The only difference is statutory license is already granted. Whosoever fulfills the conditions has a license. Now, compulsory means you have to approach the authority to obtain a license. Cross license means that I grant you a license on my technology, you grant me a license on your technology. So that's a crisscross, that is cross license. Now, license versus assignment, what are the differences? Both are contracts. The nature of transfer is different. What does it mean? That in license can be analogized to renting. Let's understand it in terms of physical property. When I sell my house to you, it means in terms of intellectual property, I'm assigning my house to you. In intellectual property, we don't usually use the word sale and rent. That is the terminology of physical property, movable or immovable property, but not intangible. In intangible intellectual property, we use license or assignment. When I license you my property, it means I'm just renting out my property to you, my intellectual property to you. So the nature of the transfer is different. The nature of title makes it different. Then there's various other differences. For example, right to sue. Now, whether a licensee has a right to sue, strictly speaking, no. But certain statutes of intellectual property grant a particular kind of licensee, that is exclusive licensee, to sue. And in that also, he must make the owner of intellectual property a party to the suit. Then breach and infringement, who can sue for breach or infringement? Well, that also depends upon contract as well as statutory provisions. The nature of consideration is also different. And then breach and infringement, there's another aspect to breach and infringement, that if a licensee infringes, then of course he is in breach of contract. But at the same time, he could also be held for infringement of intellectual property, which can attract, independent of the breach, which can attract remedies in civil as well as criminal law. Now, consideration is usually license. In license, it is royalty, and in assignment, it is called one-time upfront payment, or whatever you may say, lump sum payment, etc. So the terminology that is used for consideration differs. Now we come to another concept, division in license rights. Now there could be first geographical region. For example, I have a technology to produce a medicine. I can license it to one entity for Asia. I can license it to another entity for Africa. So geographical division is possible. Similarly, temporal division is also possible. Temporal division means that I can grant a license to you for 5 months, or for 5 years and then next to somebody else. It could also be substantive. Substantive means for example, we understand copyright to be a bundle of rights. Now, what is there in the bundle of rights? The right to reproduce, say for example, the right to translate, the right to make adaptation. So there are various rights. So substantive division of license right means to one entity I give right to produce my book, to another entity I give right to translate my book, to still another entity I give right to adapt my book into a film, etc., etc. So on and so forth. So there is substantive division that is possible in license rights. Then the last one is field of use. For example, now I give example of our past president of India, Dr. APJ Abdul Kalam. Now, he had developed, when he was working in the missile program of India, he invented a material which was very strong because it was to be used in missiles. So it was very strong, but at the same time very light, very strong and very light at the same time. That was his invention, and he had patent rights on that. So now, once it was used in the missile program, in the space program of India, then the technology was always with him. So what he did was he allowed the same technology to be used by certain manufacturers who were engaged in manufacturing artificial limbs for people who were like physically challenged, right? So, for example, making artificial feet or leg, you require something very strong, but at the same time something very light too. So this is just an example of you can license your technology, your intellectual property to different fields. You can make it, right? So that gives you a variety of usage. So this is licensing is a very, very flexible tool of intellectual property, and it can be used to disseminate your property in a very creative and flexible manner. Okay, so breach of license could be done by licensor, it could also be done by licensee, and when it is done, when the because license is a contract, when it is breached by the licensor, he is subjected to contractual liability. So is the case with licensee, but as we have already seen, if the license contract is breached by the licensee, the liability, additional liability, apart from contractual liability for infringement of IP may arise as well for or in case of the licensee. And the remedy is for contractual is damages, and for infringement of intellectual property, we all know, is fine as well as infringement. Now we come to, these were the general principles of licensing. Now briefly we'll go into the trademark licensing. Now in this one slide, I want to capture the essence of trademark licensing. It involves, let's say, three entities. First is licensor. Who is the licensor of trademark? He is the owner of trademark, right? Only the owner has the right to license. Then who is the licensee? The person who is authorized. And who is the consumer? The user. For example, there is a trademark X, which is licensed by the licensor, by the owner to the licensee. When he does so, he grants the licensee the right to use his trademark. And once the licensee has the right to use, he applies it to the goods and sells the goods. He applies the trademark X to the goods and sells those goods to the consumer. All right. So he passes it on to the consumer, that trademark. Now the consumer, in turn, what he transfers to the licensor. See, licensor, the owner of trademark, is removed from the consumer directly because the consumer has to do directly with the licensee who sells. But then the consumer transfers brand recognition to the licensor. Now, what is the worth of a trademark if the consumers do not have faith or do not recognize that trademark? So, whenever an increased sale is there by the licensee to consumer, then the consumer's recognition increases. This brand recognition increases. So, this brand recognition is transferred by the consumer to the licensor, right? because the goodwill generated for the trademark always inure to the benefit of the licensor. Then we see the consumer also transfers. Whenever consumer buys something from the licensee, the consumer transfers a part of the sale proceeds as profit, right, to the licensee. A part of that profit in, in the form of royalty is transferred by licensee to the licensor, the owner of the trademark. The licensor in turn transfers quality control. Now, what is quality control? Is a special feature of trademark licensing whereby the licensor agrees to control the quality of goods not produced by him but produced by the licensee. So he gives a guarantee, a statutory guarantee he has to give to the consumer that he will ensure that the goods provided by licensee will have a certain quality. I will talk about it a bit later, what quality. And then the whole thing transmutes into the benefit to the licensor as right over use, right? So whatever benefit to the trademark occurs because of all this business goes to the kitty of the licensor always. So this is the whole concept of trademark licensing in a very nutshell manner. Now, trademark licensing is a function of indication of source as well as a valuable property. Now, another feature of trademark licensing is that it is a loss of right as well as acquisition of rights. How? We will see. Now, let's go a little bit into the history of trademark licensing. We started with a single source function. In the beginning of trademark philosophy, when the trademark law was being made, it only recognized single source. That means the law at the time, the trademark law at that time specifically prohibited any sort of licensing of trademark. If we look into the 1940 Act of Trademarks in India, it had provisions which said that you cannot, it is illegal to license your trademark. What was the reason? The reason was that if the trademark X belongs to a person and he in turn transfers that trademark to somebody else, then as a consumer, when I buy it from somebody else, I am confused. I do not know. I am misled. I was thinking that I'm going to the owner of X, whereas I went to somebody else. Okay. So that was the problem. That was the basic, essential, foundational problem because of which trademark licensing was always prohibited. And then with the march of time, we came across the quality function. Now, quality function, when it came through, when the trademark was asked to perform the or quality function, or this quality function performed by the trademark was recognized by trademark jurisprudence, then first time licensing was of trademark was permitted by the statutes. So we see in 1958 Statute of Trademarks Act, we see a shift from prohibition to permission. Now with a condition. This permission was with a condition. Condition was that you can license your trademark provided you control the quality. Now, quality of products, whose quality of products? Of the licensee. So every licensor as owner of the trademark had a bounden statutory duty to control and regulate the quality of goods or services provided by the licensee of his trademark, right? And the law stated that if the licensor, the owner, fails to control the quality, then the license could be expunged. Now, with a third function that the trademarks are in today's world, in modern commerce, they are expected to perform, it has raised many question marks. For example, now what is merchandising? Merchandising means when I go to the market, I buy a Mickey Mouse t-shirt for my kids. Now, what company that owns the trademark over Mickey Mouse does not produce t-shirts? It has only licensed. Now, if it has licensed their trademark to be utilized by a manufacturer of t-shirts, then how can they regulate the quality? Because the quality function said that should be the measure of quality. The measure of quality should be the same. Trademark statute says the licensee's quality should be same as that of the licensor's quality. Now, that is possible as long as the products are same. But when Walt Disney Company is making films and a t-shirt manufacturer is manufacturing t-shirts, how can we compare the quality of t-shirts with the quality of films? So this has given, this merchandising function is a new branch of licensing law. It has raised various questions before the philosophy of trademark law itself. So the world is still grappling, but then merchandising today is a recognized form of licensing of trademarks. Of course, we have to do something, some rethinking about the quality functions. It has brought us at the crossroads once again, right? First, licensing was not permitted, then licensing became permitted with a condition of quality control, and now we have come, licensing is happening without any quality. Now, whether that licensing is good in the interest of business, in the interest of everybody or not, that future courts will have to decide. So trademark licensing is like trodden ways and existing fields. When it happens, it is known as brand enhancement, and when it goes to newer fields and newer pastures, then it is brand stretching. Okay, so modalities of a license, you have to talk about, in the license, the manufacturing processes, marketing methodologies, branding style, promotional expenses, advertising domains, after sales services, policing the mark, etc., etc. All these must form part of any trademark license. Now, what are the proprietors' liability for the acts of a licensee? Is there a agency relationship between licensor and licensee? Well, licensee is not the agent of the licensor. Fiduciary, is there a fiduciary relationship? Well, no. There is not necessarily a fiduciary, generally not a fiduciary relationship between the licensor and the licensee. Can the licensor be held responsible for product liability? That means an inferior product is made by a manufacturer, and that manufacturer had put a trademark on it, which belongs to somebody else. With his permission, he had put the trademark. Is there any liability of the trademark owner? Well, the modern day courts increasingly are finding such or putting the proprietors of trademark under product liability claims. Right to sue for infringement. Who has the right to sue for infringement? Strictly the owner of intellectual property, the owner of trademark always has such right, but then in certain cases, it can be decided by the contract as well. Who shall have a right and who shall have the responsibility to sue the infringer? Right to be impleaded as co-defendant, it is also dealt with by the statute. Normally, the exclusive licensee has to implead the proprietor as co-defendant or co-plaintiff. Sublicensing by licensee, well, statutes have not discussed, not elaborated upon this aspect of sublicensing. So this is left to the individual contract. So this becomes a very important part of the contract. Whether the owner of intellectual property wants the licensee to again sublicense and again sublicense. So that sublicensing can be controlled by the license contract itself. Used by licensee beyond permissible limits, it becomes infringing. And the license contract should also elaborate on this as a clause. Reasons for quality control, we have already discussed. That is the most important aspect of any trademark license. It is born out of self-interest, legal requirement, and public interest. If there is lack of quality control by the proprietor of trademark, then the registration of his trademark comes within threat. His trademark itself can be expunged. It may lead to cancellation of the license, and it may also settle him with product liability claims, as we have seen. So quality control is central to any trademark license. Now, merchandising, we have already seen, it's a function of quality control, acquisition of rights, and trafficking in trademark. Now, trafficking in trademark is always looked down upon, right? So it can be avoided when you properly control quality, then it is no longer trafficking. If there is no quality check, then this kind of trademark licensing is known as trafficking, which is of course prohibited, which was always prohibited, which is prohibited even now. So in conclusion, we can say that anything that doesn't, Friedrich Nietzsche's famous words, anything that doesn't kill me makes me stronger. So the owner of a trademark can license it to the extent it would sustain the mark itself. Go to license. This will only enhance the mark. Right? So thank you very much for this lecture and for your patient listening. Thank you. I hope you will, and whenever you will listen, you will enjoy this lecture. Thank you so much.